Thank you for joining us today for Nonprofit Commercial Co-Ventures. This is one of the emerging topics in nonprofit law over the past couple years. And one of the reasons why I really wanted to do a presentation like this for the nonprofit community is really because I see a lot of fundraising and these commercial co-ventures going on, and I don't think that there's an understanding by businesses or the nonprofit of what the law requires when you do engage in this type of fundraising. So, I thought it was important that we present today and to give businesses and nonprofits some information that they may need and some things to consider if they're going to engage in commercial co-venture. So there's a bunch of limitations, and they're similar in many jurisdictions in the United States, and different states have different requirements. But overall, commercial co-ventures is really the conducting of a for-profit business for a nonprofit benefit, right? So anytime a business has an event that says, 20% of the proceeds go to ABC charity, or, we're going to sell t-shirts and $1 from every t-shirt goes to this charity. There are some rules and regulations in which that particular fundraising activity has to follow. So what's required? In New York in particular, you don't have to file with the Attorney General to raise funds in a commercial co-venture, but there are other things that you have to do. So one of those is having a written contract with the charitable organization. And it's important that, and what goes in that contract is really driven by the statute. And it's important to have obviously the names and addresses of the parties. It's signed by both parties. It has a begin date and an end date, which is very important for reporting and document retention purposes for the business. The terms, what exactly are you going to sell and how much of the proceeds are going to go to the nonprofit? Is it a percentage dollar amount? Is it a fixed fee? Is the business have any out-of-pocket costs that, it's going to have to incur for maybe advertising or different things? All of that really needs to make its way into the agreement. New York law in particular says no person shall enter into a contract or an agreement to raise funds for any organization that isn't registered with the New York State Attorney General's office as a charity permitted to solicit funds in New York. Makes complete sense. That nonprofit has to be in good standing in order to engage and have businesses raise funds for that nonprofit. The other thing to keep in mind that a commercial co-venture can only be used to raise funds for a 501c3. It can't be a 501c4, which it could be a political organization, advocacy organization, could be a political organization. Those raising funds in this way are not permitted for those types of organizations. One tip that I tell my clients, nonprofit clients that engage in this type of fundraising, is that, you should really be careful of engaging with the same business multiple times in a row. You don't want it to look like you're patronizing that business and, that the nonprofit is really pushing people to patronize that business. Because essentially you're driving profit to the business because the charity is getting a portion of whatever, is being sold. And this is especially something to be wary of if the business is related in some fashion to that particular organization. If it's a board member's business, it's a big deal. If it's a staff member's business, it's even a bigger deal. You need to be very careful about, insiders who are receiving some sort of financial benefit or inurement from the relationship with the nonprofit, if that nonprofit is pushing business to that business that's owned by the board member or the staff member. I always tell the clients that you really should develop a process in partnership with the business. You know, the organization should be prepared to produce their IRS tax exemption letter. The organization's most recent 990 or audited financial statements, and to really have a good discussion about what the purposes the funds will be used for that are raised, and that becomes important later when we talk about advertising. Um, you need to disclose exactly what you're soliciting funds for and how they will be used. The whole process really needs to be transparent, and you have to think about it from the consumer perspective. You're asking a consumer to go patronize a business and buy a product or a service or whatever the case may be, and so that the nonprofit can receive a portion of those proceeds. So you really need to clearly describe what the promotion is and how, the consumer's purchase will benefit the charity. You don't want to be misleading at all. There's different statutes on, deceptive business practices and also, fraud and fundraising and different things like that. So you need to be, very careful about that. The consumers really need to easily determine the donation amount. So if it's 20% of what they buy, that's something that, someone can understand. If it's $1 from every sale, somebody can understand that. So you want to be as clear as possible. And, never make assumptions that the consumers know exactly where the money goes. Just because, you might be raising funds, let's say for breast cancer, and, you assume everybody knows when they see the pink ribbon what it's for. You can't just assume that. You really still need to spell it out, and make sure the consumer understands what they're purchasing and the amount of proceeds that the charity is going to benefit from. I always put in my agreements a license agreement between the business and the nonprofit that allows each one of them for limited purposes to use the other's logo and intellectual property for advertising purposes. Because any advertising that you're doing, joint advertising, has both logos on there. And, there really needs to be permission to use that. So that's always part of my commercial co-venture agreements as well. Make sure that, all your advertising, from social media posts to website to paper to flyers to signs to letters, whatever it is that you're using, has everything that needs to be required in the advertising for these type of ventures, which we'll get to in a second. And you need to keep copies of all the advertising, whether it's a screenshot or a copy of the sign, pictures, whatever the case may be. You have to maintain those for your file. The law specifically states that, advertising has to set forth the anticipated portion of the sales price or the percentage of gross proceeds, whatever, it is that you're doing, or other consideration to benefit the charitable organization. It has to include exactly what it's going to be used for. And in addition to that, the date, the time, how long the campaign is going to run. All of those things need to be in your advertising. My recommendation for nonprofits who engage in this type of fundraising is to really set goals for sales. Is it worth it? Are you going to actually walk away with X dollars? What are the price of the sales going to be ahead of time? Is it going to really be worth it for you to receive these proceeds and have the business have to be in compliance with this statute. How are you going to track those proceeds so as to not open up the business to an audit of all its financial records, but just those that pertain to collecting funds for, sales of items that were going to be part of this particular campaign? And again, you have to maintain copies of all product labels, announcements, marketing materials, whatever that is in your file. I have seen a couple of audits already by the Attorney General's Office of Commercial Co-Ventures. And of course, they're looking for copies of the contract, copies of the advertising, copies of the financial records that the businesses should produce or have produced that show the amount of proceeds that were raised and that the money actually went to the nonprofit. In no event, any later than 90 days after termination of the sales promotion to benefit a charitable organization, the co-venturer must provide the organization with an accounting of the number of items sold, the amount of money accrued from each sale, and the amount paid to the organization. That's something that is going to require, at the very least, a separate spreadsheet, if not, a report that could be generated by that vendor from their point of sale, perhaps. It just depends on, what that co-venture is working with. If the sales promotion is longer than a year, you have to report at least annually to that nonprofit, how the sales are going and what was achieved in that annual period. I always get the $1 million question: what if we don't do any of this? How do we get caught? Well, you get caught because the charitable organization is registered with the New York State Attorney General's office, and when they file their annual 990 or their financials, there is a place on the 990 to disclose commercial co-ventures and money raised from that. And also in New York State, at least, there's some other questions when you file your annual filings with the AG surrounding whether you engage in co-ventures or not. A charitable organization that enters a contract with a commercial co-venture must file a statement with the organization's next annual financial report. And what will go on there is the names and addresses of the co-venturers, statement of the financial terms and conditions of each contract, and then whether the commercial co-venture has provided any accounting as prescribed. So, the onus is on the nonprofit to report that. And at any time, the New York State Attorney General can audit that co-venture and the business that was involved in it. So it's important, I think, more so for the business that they understand that they have to maintain accurate records for all the activities conducted pursuant to co-venture, contracts and requirements for at least 3 years since the end of when the campaign ends. And you have to really, I'd keep them as long as you possibly can, especially if they're electronic, because you never know when you might have to prove something. But in no event, too, if a nonprofit asks for, a copy of the financials and the books and records, that business must, within 7 days, turn those over. So that concludes our seminar for today. It'll be interesting to see what other states begin to do with this type of fundraising. There's laws on the books in several other states already, but I think it's really about getting the word out to nonprofits and businesses that there is such law and what is required to comply with it